Good evening, and welcome to the 16th episode of the Students for Criminal Justice Reform Board podcast. I'm your host, Marissa Mack. This evening, I have with me Scott Levy of the Bronx Defenders. Welcome, Scott.
Hi, thanks for having me.
Sure, and just to give our audience a little bit of background about you, as special counsel, Scott provides critical legal and policy advice to the criminal defense practice. Scott is also counsel on Throwbridge versus Cuomo, an impact litigation practice case challenging delays in misdemeanor cases. Scott previously developed and managed the Bronx Defenders Marijuana Arrest Projects and the Bronx Defenders Fundamental Fairness Projects. He clerked for the Honorable Nancy Gertner in the Federal District Court of Massachusetts. Scott received his JD cum laude in 2007 from Harvard Law School, where he was the special projects editor for Harvard Civil Rights, Civil Liberties Law Review, participated in numerous clinical and criminal justice student groups, and worked with the Southern Center for Human Rights, the Public Defender Service for the District of Columbia, Ferguson Stern Chambers, Gershom and Supner, and the Legal Aid Board in Johannesburg, South Africa. He graduated magna cum laude from Princeton's Woodrow Wilson School of International and Public Affairs. You've been busy.
I have. I haven't heard it read back like that.
You've been busy. So clearly, I mean, your background and your bio clearly speaks to how passionate you are about criminal justice and, this entire field of making sure that people are getting the rights and the services that they deserve. Can you tell us a little bit about what brought you to doing this work and working with Bronx Defenders?
Sure. I've been doing criminal justice reform work, since I was in college, and it was really was drawn to the work since the beginning. I think the criminal justice system presents some of the biggest challenges we face as a society. I think the issues of structural racism and historical inequality are sort of most clear when you look at the criminal justice system. And I've been working at the Bronx Defenders now for quite a while, representing clients and doing policy work here to try to get at some of those issues.
That's awesome, and I think that now there's a lot surrounding criminal justice and people really opening their eyes to what's been going on for a while, but just hasn't really been brought to light. So the fact that you've been doing this work for so long really means that this is something that's a clear passion of yours and something that you really want to fight to ensure justice is really served in this area, which is great.
Yeah, no, I mean, I know nothing else at this point.
Right. Yeah. that's it. That's great. So if you would, and our conversation this evening more or less is going to be around bail reform. A lot of people have heard, of the bail system, or they've heard of bail. Can you talk to us a little bit about what bail looks like in New York City? What
Sure.
The system is, how the system's set up. Mm-hmm.
Sure. And as I'm sure you know, bail is really the mechanism that the criminal justice system in New York uses to keep people incarcerated while they are pending trial. So someone is arrested, on the streets of New York, is brought before a judge within, hopefully within 24 hours of their arrest. And a judge makes a determination about whether or not to set monetary bail or not. And bail can be set in just sort of straightforward cash money bail, meaning a person or their family have to put up a certain amount of money in order for our client to be released pending trial. Or the court can assess different types of bail, monetary bail, like bonds, insurance company bonds, which are regularly known as bail bonds. But New York also offers a number of other alternative forms of bail that don't require going to a commercial bail bondsman. This court can also set partially secured bonds with the court, and unsecured bonds with the court, that some which don't even require someone to put up money in order to be released. But as we know, many people do have bail set, monetary bail set, and many of them are unable to pay that bail during the course of their trial, and so are forced to spend the pendency of their case on Rikers Island or in one of the other detention facilities in New York City. And so that's sort of the situation that we're working with. Rikers Island recently has just over 9,000 people there. Most of them are waiting for resolution of their criminal case and are there because they can't pay the monetary bail that was set in their first appearance. And so that's really the sort of system that we're up against in the city.
So you mentioned a couple of things in what you said. There seem to be a lot of options out there, besides just money bail, right? Which we know is something that is a huge issue because it seems to penalize those that are poor, and more or less say that they are, victims. I'm sorry, not victims. They are criminals before even being heard, right? Their view is being heard. They're asked to come up with be released when they haven't even been convicted, of committing any type of crime. Go ahead.
Oh, I was just going to say, I think that points at something very important, which is that pretrial detention is really in tension with the presumption of innocence that is supposed to guide our criminal justice system, right? If somebody's arrested, that does not mean that they are guilty of what they were arrested for, and the default should be liberty, right? While you are waiting trial. So the setting of monetary bail and the incarceration of people pre-trial simply because they cannot pay that bail really stands in conflict with the presumption of innocence.
Mm-hmm. Absolutely. So do you think that New York would ever get away from money bail? Right, because there are so many other options, and I guess I would love for you to talk about harmful effects of money bail on everyone. And I want to preface by saying, I read a recent Huffington Post interview that you did, just kind of outlining all the different ways that money bail affects people. And I think we think about it just in terms of a way to get money from either friends or family, but this has serious repercussions on people, and not only individuals and families, but taxpayers are also paying. So can you just talk about how money bail is not just simply find the funds to get out? This has serious repercussions for moving forward.
Oh, absolutely. We know a few things about pretrial detention and the use of money bail. The first is that we know that people who are detained pre-trial, that is, people who are not at liberty while they're waiting their trial, generally receive worse case outcomes in their case, due solely to the fact that they are incarcerated. Many people are forced or are feel pressured to take pleas just to bring their case to an end, so that they can regain their liberty because they weren't able to be at liberty during the pendency of their case. So sort of at the very beginning, pretrial detention and money bail really distort the criminal justice system at its very sort of core by inserting pressures on people to plead guilty that may have nothing to do with actually the merits of their case. But we know that pretrial detention or incarceration generally, but especially pretrial detention, can have really devastating consequences on our clients, their families, and their communities. And even a stay of a few days at Rikers Island can lead to really problematic consequences for folks. A lot of our clients, have jobs, but a 2 or 3 day stay on Rikers Island generally results in the loss of that job. People can be dragged into the child welfare system because of short periods of incarceration. They can have serious health complications. They can miss serious or significant appointments, educational opportunities, job opportunities, wages. Ties to their family and their communities are severed and strained. And we know that people who spend even a short amount of time incarcerated before trial actually have a higher rate of recidivism due solely to the fact of their incarceration. So the costs of pretrial detention are significant, not just for our clients, but for their families and their communities. And you can imagine that those negative consequences are only magnified and exacerbated over time when people spend months, if not years, waiting for their case to be resolved simply because they couldn't make some amount of money bail. And that stands, in contrast to what we know about people's ability to return to court. As we know just from the return rates in the New York City courts, but in particular because of the experience of the charitable bail funds that are now operating in New York, and the Bronx Freedom Fund among them, they have really shown that money is not what gets people to come back to court, right? People generally return to court for their court dates, whether or not they have a monetary incentive to do so. So this money bail system that we have really doesn't serve the purpose that we want it to, right? It doesn't actually ensure people's return to court. We know that people return to court regardless of whether they have a monetary incentive. And it really just punishes people who are unable to come up with the money to bail out while they're waiting their trial. So it's really an ineffective system. And we are hopeful that the city can and the city's criminal courts can rely less and less on money bail and just release people to come back to their court dates, because we know that that's generally what people do. And so we have a very sort of harmful system of pretrial detention, and a system that doesn't really make all that much sense right now.
Yeah, and I think that's a great point. I think DC, right, they don't have money bail, and they have I think it's about maybe like a 90% return rate for the people that are released and awaiting an actual court date, or waiting to return for their court date. So there are cases where we can see that this actually works, just as you stated.
Yes, and one thing to note is that New York actually already has a very robust rate of release. And New York really stands out in that it releases about 70% of people without any conditions at all. Just they are released on their own recognizance and return to court at rates around 90%, which is what we see in other places. And in New York, we generally release people without any conditions at all. And I think that's a really important point, that we can release people pending trial without fear that they're going to abscond or leave the jurisdiction. People come back to court and they don't actually need much monitoring. What is helpful for our clients, right, are reminders and support to get to court. Many people who miss court don't miss court because they are trying to flee the jurisdiction or they're trying to avoid their obligations to the court. They miss court because they have complicated lives like we all do, right? They have jobs and bosses that will not, give them that extra day off. A lot of folks just have a lot of things going on and just need that extra reminder and extra support to get to court. And I think if we created a system that just really supported people who are out pre-trial and not really set conditions on them, we would be able to improve on the system that we have.
That's actually a great point, and I actually wanted to ask you about several ways we could do that. So, for instance, maybe just setting text reminders or other types of collateral. What are some other more effective ways we could possibly use as reminders, for people to return, even though we know, individuals will return on their own. But I'm sure there are some other, key aspects that we can focus on to help just as a reminder to return to court. What are some other alternatives we have?
Sure. I mean, I think we just need to be creative about this, and we need to think about what is really preventing people from getting to court. Oftentimes it's transportation issues, right? We should think seriously about how our clients, many of whom are low income and have or may have mobility issues, live far away from court and in places that make public transportation difficult. Often it is just the difficulty of getting to court that prevents people from coming. And we could think creatively about how to solve that transportation issue. Court, text message reminders and phone calls, those are very important. And another thing that gets in the way of people coming to court is childcare. Many of our clients are parents, and they have childcare obligations, and it is complicated, to say the least, to bring your child to court. But many of our clients don't have access to regular childcare, and so they are put in this bind. So I think we could think creatively about what kind of supports need to be put in place for folks who are really trying to live up to their obligations to the court. And I have to say, in the Bronx in particular, where court delay is a real problem, many of our clients, particularly our clients charged with low-level offenses, misdemeanors, and things like that, they're coming to court for months and months on end. So it's not just it's not just a couple of court dates, but it's potentially dozen or more court dates. And with each one of those court dates, the burden of coming to court and the sort of challenges become greater. So I think there are a lot of things we can do to support people in coming to court, and also just to make that experience less onerous and more efficient.
Definitely. And in speaking of efficiency, I wanted to talk a little bit about your contribution to the Kalief Browder story, and that seemed to play out just about everything that obviously could go wrong while you are awaiting an actual court date with appropriate information, with the appropriate people, with the appropriate backing. So besides just deciding on what type of bail or if we should set bail, what are some other areas of the entire process of receiving either a money bail or just being released or collateral bail? What are some other areas of the process that we need to consider when we're thinking about bail? Obviously, we've discussed the effects on individuals. Taxpayers pay millions of dollars to keep people in jail, for those who are unable to post. But what are some other things we can take from the Kalief Browder situation that we need to know, that people need to know?
Sure, and just a quick clarification. I didn't have any direct involvement in Kalief Browder's case, but I'm certainly very familiar with it. And what I can say is that case represents the confluence of a number of problems that really plague the criminal justice system in New York City, in New York more generally, and in the Bronx in particular. Bail, of course, is one of them. He spent a significant amount of time on Rikers because he and his family were unable to come up with the bail that had been set in his case. And for the reasons we've already discussed, our bail system should be structured to really make release the default, to make detention the very rare exception. And I think everyone can agree that his case did not merit, was not one of those exceptional cases that merited detention, right? His case is just tragic on so many levels. But there were other things that really played into what happened in his case. One of them was speedy trial, New York speedy trial law. New York speedy trial law is really not a speedy trial law at all. It is better sort of thought of as a prosecutorial readiness rule. And the main distinction is that the speedy trial clock in New York only runs when prosecutors are responsible for the delay. What that leaves out is court delay. So cases may go on for months at a time, but only a small fraction of that time will be counted against the clock. So, in New York, a misdemeanor has a speedy trial time of 90 days, but our cases regularly go a year or 2 years. Felonies have a speedy trial time of 6 months, but those cases regularly go on for years, as Kalief Browder's did. So, if we are really going to take the problem of pretrial incarceration seriously and, take the challenge of closing Rikers seriously, we need to think about reforming our bail system and making, detention the exception rather than the rule. But we also need to think about reforming our speedy trial law, and also we need to think about reforming our discovery rules. Discovery is the process by which the prosecution provides the paperwork and all the information and evidence for the case to defendants and their attorneys so that they can prepare for trial. And in New York, everyone who practices knows that New York has one of the weakest discovery laws in the country. Defendants and their attorneys are really not entitled to much at all discovery. And there are really no meaningful timelines or deadlines for the production of discovery for our clients. So clients often sit in jail without any information about what is underlying their prosecution. And so when you don't have information and you don't have a speedy trial law that works, and you have a bail system that punishes, folks without money, and particularly people of color, right? You have a recipe for disaster. You have a recipe for, a tragedy like we saw with Kalief Browder's case.
And I think all of this also too plays such a huge role in mental health, and what happens to individuals even if they are not convicted of a crime, and what their life is like afterwards, right? So, obviously in yes, discussing everything that happens to their families and their jobs, but you're taking individuals through this cycle and then expect to, rule a decision either way, and have people just return as if nothing has happened. We know that there are violent acts that go on within Rikers, and there's mental abuse. So on top of everything else you've already discussed, people are either being convicted or, let go, having how many days in jail, right? Or having all of this additional, all of these setbacks posted upon them, which is a completely different level of living your life and prospering in my eyes.
Yeah, I mean, jail is not good for anyone. As I mentioned before, we know that even short periods of time in jail can actually lead people to reoffend more, right? The term we use is that, pretrial detention is actually criminogenic in and of itself. And we know that Rikers, has had real problems for years. And that we need to think long and hard before we send anyone there, right? Because the costs, not just to taxpayers and things like that, but the costs to our clients, their families, and their communities are astronomical, because health issues and mental health issues are exacerbated and made worse while people sit on Rikers Island. And those costs are not insignificant. And ultimately, right, they make it more difficult for people who are released, because most people are released, make it more difficult for them to you know, join their community and live productive lives afterwards. So,
Absolutely.
you know, a lot of what we're doing in the criminal justice system and in the pretrial justice system in particular is really counterproductive to the overall aims of, you know, justice um, and you know, sort of a holistic approach to our criminal justice system.
So there are two things that you mentioned that I really want to get to. I'll start with the first question. And that is, do you have the proper information to assess the type of bail they should post for an individual? So I know we've already gone over that, you know, a good amount of that appear are released without bail. But for those who do have bail set, you know, are they properly assessed, you know, in terms of their flight risk? Do judges have all the information they currently need to really assess, you know, what should happen? Because as we stated previously, you know, the repercussions are very detrimental on all ends. So are judges equipped with everything they need to make the proper decisions?
I mean, I would maybe reframe the question. I would say, you know, it's less about do judges have the information they need, and more, are judges taking the time necessary to make the reasoned decisions that they should be? You know, in other states, and I'll explain what I mean. You know, in other places, when a detention decision is made, there's an initial detention decision, but then, you know, maybe a day or so later, there is a robust evidentiary hearing where people can marshal evidence and call witnesses, and discovery is actually provided to clients and their attorneys to prepare for that hearing. And I think then that would be a step in the right direction, because, you know, taking away somebody's liberty is a serious matter, and I think we need to devote the time and resources sort of that correspond to the seriousness of the decision that we're making. And far too often, it's less about whether the judge at the first appearance has all of the right information or not. It's that they don't have the time or the incentive to really dig in to the case, and they don't have evidence before them, and they don't have live witnesses before them. And so what happens is, you know, we interview our clients, we go before a judge, we do our best to get as much information as we possibly can, but and we present and we make the strongest bail argument that we can to the judge. But, you know, at most we have, you know, a few minutes in front of the judge to argue that issue. And the judges make their determination, and far too often that determination, which is made right at the beginning of the case with not much information, carries through the entire case. And one of the things that we know is one of the biggest determination, one of the things that determines whether or not a judge will set bail, one of the things that influences that decision is whether the DA asks for bail and how much they ask for, right? That is actually the thing that influences judges' decisions more than anything else. And that decision is made without much information. And so what I would push for is actually more due process, right? More robust due process. To say we should discourage the setting of bail and the detention of people at first appearance, because we know we just don't need to be detaining people at all, right? We should be releasing more people from first appearance and let people come back to court and fight their cases. But for those people where detention is contemplated, we should then really take the time to make a proper determination about whether or not, you know, the conditions that might be set are really the least restrictive conditions necessary to ensure this person is going to come back to court, right? That is the standard that I would like to see. I would like to see prosecutors have to prove that the conditions that they are asking for are the least restrictive conditions necessary to ensure that person's return to court. And we should have as we do in all other parts of the criminal justice system, adversarial evidentiary hearings, so that judges can really dig into the issues that matter and make decisions with sort of full visibility. As I like to think about it, I would like to see a reform that really mandates thoughtfulness, right?
Mm-hmm.
in detention decisions.
Right.
And I think that's really what's missing often.
Mm-hmm.
So yeah, I would like to see more robust due process. It's sort of a fuddy-duddy concept, but I'm a big believer in due process.
Absolutely, and I think more time will produce better outcomes for individuals. You could potentially be holding the life of someone in your hand just by the type of bail that's being set. So spending a little bit more time on that is definitely a win for everyone involved. So the second question I had,
and I think, and just to put a point on it, I think along with that due process, we need a system that makes clear to judges and to prosecutors that detention really should be the last resort, right? Mm-hmm. Detention should not be the default. It should not be the norm. We shouldn't just sort of haphazardly ask for bail on in cases that really don't merit it. And for those very, very few cases where detention is going to be contemplated, we should take those decisions seriously.
Yep, the effects are too great not to.
Yes.
So the other topic that I wanted to discuss, which is a heavy topic now here in New York City, that everyone is aware of. We know in 2016, the mayor announced a $17.8 billion bailout reform program, allowing low-risk defendants to return to their neighborhoods and basically try to shut down, Rikers Island and going. How do you feel like the shut down Rikers Island process? Is everybody on board to do this? What is this going to take from the standpoint of bail? How are we moving forward with this?
I will say it up front that I think, if you had asked people a few years ago whether they thought closing Rikers Island was a real possibility, I think the answer would have been no. And I applaud everyone for really having the political courage and the sort of imagination and desire to close Rikers Island, right? I think that is a crucial and important thing that we need to be working toward. I think we need to be doing it faster. I think the longer we give ourselves to close Rikers Island, the less likely it becomes that it will ever close. And so, we are very much in favor of, shortening the deadlines and pushing up the timeline on closing Rikers Island. To be sure, there's some very complicated issues involved in closing Rikers Island, but we would like to see it closed sooner than later, and we think that in order to keep the momentum that we have, we need to really hold folks' feet to the fire in efforts to close Rikers Island. That said, I think there really are. I think people in the city are really committed to this project, and I think. But what I would love to see, and I think what we hope to see, is that the sort of courage that was required to sort of say we're going to close Rikers continues through some of the tough decisions that are going to have to be made down the line. To really reduce the population of Rikers Island, we need to radically rethink our system of pretrial detention. We need to be releasing more people pre-trial. We need to be providing more support for them. And I really can't emphasize that enough. It's not about setting conditions on people when they're released. It's about supporting them so that they have the means and the ability to return to court. And so, I applaud many of the efforts that are underway. We certainly would like to see the rates of release increase. We would love to see more support. And I think would love to see as well a commitment to going after some of the harder cases on Rikers Island. Because I think anybody who looks at the numbers and the data coming out of Rikers knows that if you really want to close Rikers, you have to deal with people who are charged with violent crime. And I think reducing the Rikers population and reducing the population of people who are charged with violent crime is going to take some real both political will and courage, but also some creativity and some willingness to think outside the box, to make opportunities available for clients to be released and to sort of be in their communities while they await trial, and to not have this sort of reflexive desire to incarcerate people based on sort of the, based on their charge. And so I think that is going to be the one of the tricky things that we're going to have to tackle. And I'd love to see people tackle it head on, right? There are important things we can do to make sure that the pretrial justice system, really is only used in the rarest of occasions. And right now I just don't think we're there. But my hope is that we will move there over time, and that this momentum that we have will carry over to some of those harder questions.
So in saying that and saying, the hopes for talking about the harder questions and moving forward a little bit more quickly than we currently are, what can individuals do? What can I do? What can members of the community do? On an individual basis, or even joining with an organization. What can we do to help bail reform? Also, what could we do to help the shutdown of Rikers move a little bit quicker? Just as individuals, what are some things that you think we can do?
I think there's a lot that people can do. This effort and this campaign to close Rikers Island really requires sort of community engagement at all levels, right? So there is the Close Rikers campaign, right? That is a campaign dedicated to the issue of closing Rikers, and there is a policy platform, and there are community outreach efforts and political actions and things of that nature that folks can get involved with through the Close Rikers campaign, right? And that is an important and impressive coalition of community groups and advocacy organizations, all sort of united around this this goal of closing Rikers. And that's, you can get involved through your church or your temple. You can get involved through various advocacy organizations in your neighborhood or at the city-wide level. You can go to city council meetings. You can, contact your city council person. You can talk to, borough president's offices and the mayor's office. There are many, many ways that people can get engaged. And I think there's ways to get engaged for people, whether you have 5 minutes or you want to dedicate, a large chunk of your time. Because I really do think that this is going to require engagement at all levels for a sustained period of time to make sure that this very ambitious goal is actually attained and attained on a timeline that is, that reflects the sort of justice interests at issue. And so, there are lots of ways, but I definitely would encourage people to look into the Close Rikers campaign. It is impressive and it's important, and hopefully it will lead the charge for accountability.
Absolutely, those are great takeaways and great ways to get involved. I think you listed just about every way that someone could, potentially use their time to move any of these initiatives forward. So as we wrap up here, I've enjoyed speaking with you, and I just want to ask if there's anything else that you'd like for us to know, anything that you're working on currently through Bronx Defenders or on your own that you want to share.
Well, sure. As we were talking about before, I think, and we at the Bronx Defenders think that real pretrial justice reform requires, changing the way that we administer our bail system, but it really also requires changes to our speedy trial law and changes to our discovery law. And those things happen at the state level, right? There's also a campaign to address those three things: bail, discovery, and speedy trial at the state level. And we are really committed to, reform on all those three issues, because New York's criminal procedure laws really are an obstacle to closing Rikers. And I think Khalif Browder's story shows exactly why and how our current law does not serve the ends of justice. So, we are going to be looking very hard and working very hard to improve New York's bail system, speedy trial law, and discovery law. And if folks want to look into that, the Close Rikers campaign also has a legislative platform that is very, very important to this effort, and that's, I think, where we're going to be focusing our energy in the months to come.
That's awesome work, and I'm glad you were able to share that with us. And I again thank you so much for covering this extremely important topic with us. And we are all left with different ways where we can get involved and make sure that pretrial detainees are actually fairly treated, and even look at the process before even getting to that point. So again, I want to thank you so much for joining us this evening, and during our little hiccup earlier before getting on the call, but I appreciate it. And thank you again, and enjoy the rest of your evening.
Yeah, no, happy to do it. This was great. And we'll talk. We'll talk soon. All right.
We will. Thank you so much, Scott.
Okay.
Have a good evening.
Take care.